welcome to Daily Interesting. We are, sorry, I got to turn the music down. We are talking about day 4 of the Zac Anderson trial, and we have Steve Gosney with us today because we have DNA, or we have the suspicion of DNA. I don't know how credible it's going to be. We also have burden shifting, surprise testimony from expert witnesses, and misstatements of Zach's girlfriend at the time. So that's what we have in store for you today. Welcome, Steve. Thank you for joining us.
How are you? Well, this was a little impromptu, but I got done with my stream and you invited me, and I'm a little bit. I'm here. I'm an appellate lawyer from Florida, and I thought that, of course, I'm a big friend of the MLS Law Show, and of course, Zac Anderson. From what I have seen, there is a crazy injustice, and we public defenders are, if anything, are motivated by injustice, and so I hope that justice is served in this case. And I'm not a Wisconsin lawyer, but I will offer what insights I can on your stream.
Thank you. Thank you for being here, Steve. Really appreciate it. So today we started today off with Christine taking the stand. Christine was the woman that Zac was dating at the time of arrest, and Christine Remsburg. Now, there was something about the way that the prosecutor had presented her statements. What he tried to frame to the jury was tremendously dishonest. He came out to the jury and told them that she was intentionally trying to cover up or intentionally trying to mislead investigators about Zac and her whereabouts on the night of the 17th. But that couldn't be further from the truth. The fact of the matter is that even in her statement to the police on the 17th or on the 19th of May of 2020, she said, "My memory's not really good. I think he was by my house, but you would have to ask my sister. She would know." So she's actually very forthright. She's forthcoming with the police investigators, and that is mischaracterized to the jury. And it's just another piece of that bad man in action. He's intentionally, as a malicious actor, trying to frame this in an inaccurate way for the jury to lead them to the wrong decision in the end, for the sake of a conviction, not for the sake of justice.
Yeah, and she didn't seem to be very with it. I understand she might have some substance abuse issues that she may or may not be recovering from. But she's not necessarily the most reliable witness. But she's key for the state's case because it shows, presumably from the state's point of view, an intent to lie about his whereabouts when during the timeline that the state says Rosalio was unalived in his apartment.
Yeah, so he wanted to prove with her was the use of the car. He wanted to try and negotiate with the jury the usage of the Audi, or as he said, the Audi, versus.
That's how I would say it, anyways. The Audi.
Yeah.
But yeah, so with her was definitely some misstatements of her actual statements, which he doesn't really apologize for. He just sort of sits there with this smug look on his face, and it is what it is. It's gravely. The next witness. Well, I don't know if you were done with her. If you wanted to say anything else.
No, that was it. I mean, you could see the heartbreak in Zac's face, and for anyone that is talking about body language, he's in pain watching her take the stand in her condition. It was painful for him, and it broke my heart when I watched it the first time. I was friends with Christine for years. She worked at the same restaurant that I was bartending at part-time, and it was painful for me to watch too. So our hearts go out to her. I really do wish her the best, and I'm sorry that she was forced into the middle of this really messy ordeal.
Maybe you should say, maybe a better way to say that was, she was used by a prosecutor who is seeking to win at all costs by insinuation. A prosecutor, and I had a conversation about good prosecution on my stream just recently about how to properly prosecute a case. And one of my main things as a prosecutor is an advocate for justice and truth. and your object is clarity and directness. Insinuation does not serve the state. Insinuation is not evidence. And that is a real comment on the advocate that you have before you who is seeking to win at all costs rather than prove the case beyond a reasonable doubt. And the innuendo is beneath an advocate, a prosecutor, a state representative, because innuendo is not evidence beyond a reasonable doubt.
Yeah. Thank you.
That's
well said.
And yeah, no, that's the key thing that I think everyone is missing here is that, well, of course the prosecutor wants to win. The prosecutor represents the state and they, they deserve to win or whatever. It's not about that. Hey, Nate the lawyer in the chat.
Look, he's throwing sand in the gears here. Hey Nate, how are you?
Juicy.
A while actually.
What do you call live? Three guys on a live stream. Barely interesting. Great stream. Yes, thank you very much, Nate.
Yeah, thank you.
He threw off my train of thought. What the hell was I going to say?
We were just talking about the winning at all costs, and that's the piece that we're missing here as we talk about Gravely being a dishonest actor, because it is that he's not being a good representative of the state in the pursuit of justice. He's violating the pursuit of justice in the tactics that he utilizes.
Right, exactly.
What I was going to say is that justice is the fairness in the process. It's not the outcome, right? Exactly. So everyone wants to talk about we got a conviction, so the victim's family has justice. The justice is the fairness in the proceedings. So that's the justice that's supposed to be there. And so when you say that the prosecutors are there to seek justice, they're supposed to be there to make sure that the facts are presented and not necessarily to get a conviction.
Like Bronca said earlier today, that he loves the process in the justice system is beloved and should be sacred. And if you can honor that as an arbiter of justice, then the system will be just. As soon as you undermine that, the system becomes inept and unjust, and we have that in Zac's case. So let's move on. Let's carry on to the next topic. We have our second witness, who's Eric Widener. Eric Widener is an evidence technician, and most of what they talked about with Eric Widener on the stand was what was swabbed, what wasn't swabbed, what they did, how they collected, what were the reasons that they collected evidence. And that was to establish a little bit of the weakness of the police investigation, the failures to test certain items, like the credit card holder, like the money clip that was in the freezer. Like
I want to slow you down real quick, because this is important, right? So this guy is here to establish what evidence was swabbed for DNA and fingerprints, and essentially on cross-examination what evidence wasn't. Now he's an evidence scene investigator, right? So he's supposed to be swabbing things that might lead to the identification of a potential criminal suspect, right? He doesn't swab the wallet that's found in the freezer with the credit cards, only the phone. He swabs the door because it's a point of entry, but he doesn't swab the window that's opened because that wasn't a point of entry. He's just sort of like, he swabs one bottle of water but not the other bottles of water that are open. He's just randomly selecting things, and this is where the burden shift comes into play. Hey, Uncivil, welcome. This is where the burden shift comes into play, because what the defense does on cross is ask this guy, you didn't test these things, you didn't test that. And then on redirect, Gravely goes into, but the defense could have had these things tested, right? And that's where originally there was an objection, and the judge sustained it, saying that you're asking this officer for a conclusion of law or legal interpretation. And then when Gravely rephrases the question, but asks the exact same thing, the judge eventually allows it. The objection is then again made that this is a burden shift and is improper. And then there's a whole an hour or so of argument regarding this. So So that's the burden shift that was addressed today. Steve, what are your thoughts on that?
Let's, as for beginners and for even us experienced folks, burden shifting can be a little complex, especially even trial attorneys miss this issue. And I commend the defense team for seeing that issue, because it's one that often gets missed by the defense. So the fact there's an objection means it's projected. But what is a burden shift? Well, everybody knows the proof beyond a reasonable doubt standard. That is the state bears the burden of proving a crime in every element of that crime beyond and the exclusion of every reasonable doubt. That's the standard. Most people know that in America. I mean, it's it's the highest standard in law. It means that all the states. So if the defense could sit there and just say nothing at all, and the state could still lose, because it's not a contest between two parties. It's all the burden over there to establish a mound on each element that exceeds that burden, that high burden. So what a burden shift is, it's a technique, it's an improper technique by the state, by the prosecutor, to relieve themselves of some of that heavy burden by saying, well, look over there, the defense didn't prove something, or the defense didn't disprove something. By shifting the burden over to the defense table, they have effectively lessened their burden. They are misleading the jury. It is not lawful. It is not the law. The law is the burden is on the state beyond a reasonable doubt. And so for them to imply in a question or to say, for example, this defense didn't disprove this, is in effect a burden shift from the state to the defense table, and it is legally improper. And that is the type of thing that, if properly preserved, is subject to appellate review.
Now, do you think, now I know you're not a Wisconsin attorney, and this isn't legal advice, obviously, but do you think that is something strong enough that could justify an overturning that alone with regard to that burden shift? Because the DNA is a big part of this case, right?
That's a very hard question. It depends very much on your court and your jurisdiction, and how defense friendly they are, how prone to rubber stamping lower court judges. It's very hard to get anything overturned on appeal. I'll just say that is a high standard. It can be part of a collective problem. So, for example, this is one issue. That issue alone may not be sufficient. They'd say, well, in the totality of the circumstances, in looking at all these things, it was harmless. And they love to use harmless error as a way to escape from error. However, if you list it amongst many, many errors, you can have something called cumulative error. And cumulative error is, okay, this stick and this stick and this stick do not individually weigh the scale of justice so much that it was an unfair trial. But when you total those sticks together, it is overwhelming and requires a new trial. So that would be one of those points that I would make for sure, especially if it's preserved. But then I would also make sure to add in an appellate point, if it was in Florida, that this was she said the other what I said before.
Steve's had a long day today, folks.
Yeah, sorry.
We need to get you a sidecar, sir. So, I mean, I think that this learning lesson begs at least pointing out that our not so friendly friend Michael Gravely did learn something today. He learned a few things today. Not Gravely today. Today's the judge. Well, a little bit of both, I think. But I think that we have the clip of the judge learning something or remembering something from his first semester of law school.
This is, by the way, going to be a running thing throughout the rest of these streams. We're going to have a little bit of learning time. The more you know, right?
Objection. Calls for hearsay.
The objection. Well, it's leading.
This is cross-examination.
Right.
So I can lead.
Yes, you can. Yeah. That was in first year of law school.
Yeah.
That was a long time ago.
It doesn't matter how long you've been practicing. You can always learn something new.
40 years on the bench, and he forgot the rules. So So there was that one. There was also a moment where Gravely just objects to hearsay because the defense lawyer on cross asked Christine Remsburg to just tell the details that she remembered from a date, from the date of Zach's arrest, and immediately he objects to hearsay, and the whole courtroom froze. And the reason is why is it hearsay? Because there was no hearsay in the statement, there was no hearsay in the question. And he said, well, on grounds that it's too broad, I think that it's going to bring hearsay in.
Okay.
So in the interest of the court, we must keep it out.
All right. So hearsay, of course, is an out-of-court statement. What Gravely was talking about is that Zach's girlfriend, what he was thinking was going to happen is Zach's girlfriend was going to say, well, Zach said this and this, which would be hearsay. But that wasn't the question. The question was, this was the day that two guys showed up at Zach's house. And the question was, okay, what did you see? What did you observe? And he objects and says, I think she's eliciting hearsay. And the correct response from the defense was, I'm not. I'm just asking what she saw. That's not hearsay. What she was feeling, what she observed, none of that is hearsay. And then the response from the judge was, well, I think what he's doing is he's preemptively objecting because he wants guidance from me on whether or not this witness can testify to X, Y, and Z. It was ridiculous. Basically guiding the prosecutor through how he's going to argue the rest of his objection to this question. And then it was all for naught because she ended up just testifying the same way. But it's seeing the judge and Gravely discussing these things. It's like they're learning on the job, and it's a circus of a trial, really.
Right, and that's a problem. If you have a weak judge and an unethical prosecutor, it's a bad combination, and you convict the innocent with that combination. I've seen it personally.
That was. Sorry, I didn't mean to.
Well, I was going to explain a little bit, just since we're kind of doing basics, and I'll try to do my role here, which is hearsay is an out-of-court statement for asserted for the proof of the matter asserted. So you're asking about some out-of-court statement. Now, it's in this case, the objection would be proper if you were soliciting statements by Mr. Anderson, because he's the defendant, and there's actually a Fifth Amendment waiver issue. There's a lot of issues in that. But what is not hearsay are actions that are observed and visuals. And so that is, hearsay is a statement. So that means something that is verbal, something that is said. If it's observed, if it's smelled, if it's saw, if it's taught, right, if it's felt, those are not hearsay. Actions, it's not hearsay. How somebody reacted, that is not hearsay. Now, if they said something, I didn't do it, or then that would be hearsay, because now you're trying to get something in that was said through the back door. But if it's not a statement, it doesn't fit the definition and is not hearsay.
What's interesting is that Gravely was attempting to do the very same thing just the day before, was to solicit hearsay statements from the detective Anschutz about what Sadie was saying to him. And that was allowed over the defense's objection that he was actually asking, so what did Sadie tell you? Yeah. Now, it was eventually admitted for effect on the listener. And there was a little bit of an argument regarding present sense impression. But so what he's, and I'll kind of simply, I feel like now I'm in class again. So this is I'm going to put my professor hat on, American law professor hat. In evidence class, it's about half the class is hearsay. And what it is you get this definition of hearsay, and it makes sense. But what you have is, first you have, does it even fit the definition? In which case it's not hearsay. Like, is it an action? Then you get the statement, it is hearsay, but there's an exception that applies. And there's a list of 50 exceptions, right? And so you're always accepting it. Now, one of those is effect on listener. So what was said can be brought in if it has an impact on your action. So, for example, something was said to you and like, well, why did you run? Because this guy shouted to me, duck. All right, well, the fact that person said duck,
right? Or he's shooting at you, right? That's a statement, but it's not being offered for the matter of asserted. It's being offered to explain why the person ducked ran, right? So that is an exception. So it is hearsay, but it is allowed. And this is a very complex subject of evidence. But then when you say and we start using jargon as lawyers, truth of the matter of asserted, that's a hearsay exception. And it's like, oh, okay, that's what that is. Or effect on listener, that's a hearsay exception. So that's what we're talking about.
Yes. No, I appreciate you explaining it more detail. And yeah, Andrew
Steve,
Bronk is in chat.
that
no spoilers.
We're gonna have to like set up bubble charts, and we're gonna have to like flow chart through this for the listeners to really comprehend what we're talking about. But
you know, I have my evidence notes from law school, and actually, one of my streams, I just like pulled them out and started looking through them on screen. So I might actually do that at some point. But but that the point in me talking about that was the two-faced nature of the prosecution and the court versus the defense, because it's not just this case, it's a lot of cases. It's cases that I deal with, and you know, I don't want to get on a tangent, but it's just
well, what you're saying is
you're
saying the rules for are different for the state than the defense, and actually that is true, because the state does not have rights. And I always, I love it when the state likes to say, the state has a right to a fair trial. Absolutely not. The rights are imbalanced. And
Steve,
so
there's with the Denny motion, the Denny case itself literally says the state has a right to a fair trial. And therefore, we have this whole Denny rule in Wisconsin. It actually says that.
Yeah, I don't like the Denny rule, and I haven't studied it. But when I looked into it, I'm like, this doesn't seem to be consistent with my understanding of constitutional law.
Yeah,
and maybe the Anderson case will be the one that overturns the old Wisconsin Denny rule.
I'm praying.
Let's hope
Steve.
so.
I'm praying. So let's segue a little bit, because we were talking about the relationship with. With the prosecutor and the judge. And I think that really goes back to Schrader's cognitive awareness. And you can tell, especially today, where he's getting confused by the arguments, where he's forgetting things like we just played this first year of law school, fact where you can lead a witness on cross. These are issues that are consistent with Judge Schrader in this trial, where he's making bad decisions, or he's not making decisions, or he's making poor judgments. There's another objection that is brought back to his attention later on today, and I forget which witness it was in regard to.
So it was with Truffinger, or however you say her name.
It was with Trevor.
And it was redirect from the state, who was asking her about bleach, and bleach wasn't brought up on cross-examination. There was an objection to that. And then they did like cross and recross a couple of times. And it was brought up later. And the judge forgot that the defense objected to the whole bleach angle. So is that what you're referring to, I think?
Yeah.
He completely forgot. He's like, well,
totally.
did you object contemporaneously? And she's like, yeah. And he's like, oh, yeah, I did.
That's right.
Or you did,
object. Yeah.
Yeah. So, yeah. So it's bad. It's bad judging at that point. If you forget where you were and what objections you overruled, in fact. But this is everyone's favorite witness, Lisa Treffinger. She was the next to testify. And she was the DNA analyst that tested all the swabs that this witness had taken from the apartment.
Both he and Van Wee.
Oh, yeah, he and Van Wee. From the apartment and from Zach's van in a bunch of locations. I feel like they did more DNA testing at Zach's house than they did at Rosalio's apartment.
That's what it feels like.
But so Lisa is the one who tested it all. And she's actually has an ethics complaint filed against her as a result of her testimony, because it was not scientifically based. At all. She testified to things way outside of the scope of her expertise.
This was terrible. This is the one thing that Nick Starra exposed me to this, and This was so painful to watch. There's a form that you just click through. Doing this type of cross of a DNA expert, it's very form based. It's very checklist based. And I have it at work. If I was at work, I could pull it out off my shelf and just go through the questions 1, 2, 3, 4, 5. And I remember when Nick Starr said, "You got to see the Zac Anderson case. I'm going to show you this DNA thing," and he blips it up. And it just was completely foreign to my understanding of the way it's done. It was very seat of the pants. And scientific evidence is anything but seat of the pants. There's a reason that you have a formal structure for presenting evidence like DNA. It's very specific. It's not something you just throw out there and then say, "Oh, well, DNA says he did it." I mean, there's method to this, and the method was not followed. And for her, as supposedly a scientific testimony person, to allow herself to be used like this and to make opinions outside of what is within the narrow scope of expert testimony, to me, this was really problematic evidence.
You know that she is the person that maintains the integrity of the Milwaukee facility. She's the person that is supposed to make sure that this testimony is done properly.
Yeah, she's the one in charge of reviewing everyone else's work now. And she was at the time of her testimony, although she wasn't at the time of the testing. The time of the testing, she was still working in the lab.
Well, and the other point is that it's kind of like good cops and bad cops, right? I respect police, and there's a lot of really good police officers out there. But the bad cops drag so many of them down, and the good cops have to speak up and not. Bad cops are the worst thing for good cops. They should be expelled. It's a terrible thing. Same thing with this kind of DNA science. You get an expert like this who starts opining the way she opines, it really drags the profession and the science down with it. It's very poisonous to the system to have this type of case in existence and out there.
Yeah, and one of the things that she testified to at the very leading questions from Gravely was that everything that she had to say was to a reasonable degree of scientific certainty. Now, while that's the legal standard, that's not the medical standard, the scientific standard. Also, something interesting that I didn't catch and that Branca actually caught earlier during his stream watching this is that since Gravely prefaced that everything you're going to testify here to is to a reasonable degree of scientific certainty, that means everything she testified to is, in her mind, to a reasonable degree of scientific certainty. That includes the bleach kills DNA stuff that she had no basis for that. There was no foundation for that. That includes the marks in the van were blood or whatever she testified to. All of that is based on the framing of the question to a degree of scientific certainty. So with that understanding, Steve, do you think it makes attacking this easier or worse? Because you've seen part of her testimony.
Yes. Well, and this is the one thing that I actually, like I said, did watch on the trial. And I had something going on and I couldn't watch this trial, but I remember how upset all my friends were. Okay, so the question is on appeal, if we're asking, because we're at the appellate stage, is the improper presentation of the scientific evidence something that is subject to appeal? I'm trying to think of it. I always go back to my reservoir of appeals that I've already done. I would like to say yes, especially since science has such a high level of credibility. In Wisconsin's a Daubert state, is that correct? Or
yes,
hybrid state, right?
Daubert hearings.
Yeah, they have Daubert hearings here.
Okay,
in Wisconsin. It's a Daubert state. Yeah.
So the fact, if the judge did not put there is a question about, because DNA is going to be coming in as Daubert. The question is the presentation of the DNA. That's a good question. I'm going to punt on that one. It's a very good, I probably is. I would definitely look into it. The answer to say yes, absolutely, it's an appellate issue. I'd have to look at the Wisconsin law and see exactly.
You know, yeah. I think that, so I've reviewed the American Bar Association standards for testing the evidence. And, you know, we've talked a little bit about the impropriety of the testimony of Lisa Treffinger, but we haven't touched on the impropriety of the actual testing. It was consumed. It was consumptive DNA testing. And this,
which means that there's no remaining sample that can be tested.
So the defendant's team, or the defendant has the right to be able to retest to ensure the truth or the error that could potentially be inserted by a test that had gone wrong. And when you have something like this, where the one almost microscopic specimen gets completely destroyed in the testing process, the American Bar Association has a special set of rules to follow for this. One of them is that the defense has the right to be able to file to keep it out of the entire proceedings because it was consumed and therefore unreliable. Secondly, if the judge rules that it really should be in because of the relationship between probative versus what's the word, David? Prejudicial versus probative ruling. Then they have an obligation to photograph, videotape, and record every step of the collection through testing, every single step, to ensure the veracity and the lack of tampering. And none of that was done. So we have no idea whether or not this specimen was contaminated during any of the processing and testing that happened after that. So even if we accept this as something that could be in the court, we also have further problems with this because they didn't even follow the proper procedures of consumptive testing. This is prejudicial and unreliable because of that. And because of the issues with this, we also have the single data point, this one item that doesn't fit the rest of the thousands of man hours, the 15 police agencies that were involved in this investigation. And they've found one speck of DNA when the rest of the van, the entire rest of the van, had 0 specks of the victim's DNA. So where does this make sense? It is more likely that this is an error in processing than it is actually something that proved that Zac was connected to Rosella.
I'm gonna push back and play devil's advocate a tiny bit. All right, and there's a problem, and we appellate lawyers deal with this. So I'm going to show you that there's a problem here with this argument. And this is hard for me to say, but I'm just reflecting what I observe the courts doing. Is what we'll say is that this is an error that is subject to discipline and regulation of the body. So they didn't follow the procedures, and that doesn't affect guilt or evidence. It goes to weight rather than admissibility. Therefore, if it's admissible, the jury is to decide, and if any errors are subject to professional discipline by the agencies. You get this a lot of times with bad police officers. So we have bad police work, and then this is the appellate judges and the pro-cop, the pro-prosecution, and the pro-guilt system, criminal justice processing system, that what happens, and what they say is, you're trying to get off on a technicality because the cop did a bad investigation. Well, whether the cop did a bad investigation or not doesn't impact the guilt or innocence of the person accused. Now, as a public defender appellate guy, I agree with you, and I think that there's a lot of injustice in exactly what. Now, the fact that the evidence was so tiny that it was consumed adds these additional layers of protection, which should be followed. But when it's not followed, is that prosecutorial error? Is that judicial error? Or is it something that, well, they just didn't follow their procedures, it doesn't affect the weight or disability, and they were able to argue that to the jury, so it's all harmless? This is kind of this is the problem you get into in appeals. Now, I also agree, but I'm a defense guy, and I think like what you're saying, and especially like I think this is another one of those things that I think you put into the totality of the circumstance. You put it on cumulative error. What? Oh, shoot, I keep missing the word. You
Yeah.
put that in the basket of sticks as another thing that caused error, because DNA is such a powerful thing. And I remember this DNA thing when he misrepresented what that DNA result was and how it came out. That is a huge weight. That is a heavy stick on the bundle of error. And so, because DNA has such import with juries, that adds to its weight and its harmfulness against the defense. So I would definitely make the point. I'm just saying that appellate courts miss it this way.
What I was thinking of framing it as a improper inference being made to the jury because of the way the DNA evidence was presented. That I thought would be a stronger argument. But again, I don't do criminal appellate work. So
yeah, I'm just saying this is how they see it.
On,
they see it through the lens of like bad cops doing an investigation, but that doesn't affect the guilt. They see it as like a disciplinary issue.
Right. But I was saying what my thought is the presentation of the evidence, that this was essentially everything that I say is to a reasonable degree of medical certainty. Let's start with that. And now I'm going to say I tested, some toothbrushes, some hairbrushes, some blood around the apartment, and it absolutely matched the DNA I found in the van. I mean, that's essentially how it was presented, right? There was no talking about, the possibilities or whatever. It wasn't presented the normal way. So with the presentation giving the inference that this is absolutely 100% his DNA, despite the fact that the defense cross-examined and showed that there was a stray allele and all these things
there
out
were
there.
all kinds of problems. To me, it was not strong DNA evidence at all, in addition to the absurdity. I mean, I've been around, I've seen and read too many murder scenes and too many crime scenes. The location, what they were representing as DNA evidence in this case is absurd. If you've ever been around a murder crime scene, it's just ridiculous what they were saying. It was like a pinpoint on the van side on an area that they said, well, he cleaned this area. There's their allegation. It was cleaned up. And for that pinpoint to exist on the place that it was at exactly the most reasonable spot that would be cleaned, and for there to be no other blood, it's an absurd view of murder crime scenes. But if you're a jury and you don't know, and you hear this DNA expert, gee, they said it was this thing, and you get confused. Well, they're cross-examining, but it's DNA and it must be scientific. It's a very easy thing for a jury to misunderstand. And that's why the harmfulness of this error is great. And that's an advantage of this point in an appeal.
So I think that that we're coming down to like the last 5 minutes. We have one more really big topic to discuss yet. That's going to be ambush, right? I think that this is the last, as Branca said earlier today, if you drop a piece of shit into a 5-gallon bucket of water, you don't have a bucket of water anymore. You got a bucket of shitty water. And so that's what we've got.
Sounds like Andrew. I like it.
We've got a bucket of shitty water from this day of the trial. And the last one is ambush tactics by the prosecution. David, you wanna take this?
Well, yeah. So essentially, he's in the chat saying it too. So what he's talking about here, there's the primary thing is the bleach, right? So Gravely is questioning Lisa Troffinger, however you say her name. Sounds like a
Treffinger.
It sounds like a cookie. But so he's questioning her about bleach and whether or not bleach kills DNA, and if essentially that, right? But that wasn't contained in any of her reports. There was no notice given to the state ahead of time that she was going to be called to testify about bleach.
No,
there was
also given to the defense, not the state.
I'm sorry, to the defense. Excuse me. And there was also no foundation to establish that she's even knowledgeable about the effects of bleach and what the percentage of the bleach is that could have been used or anything like that. So it's really it's an ambush, I guess, or no notice was given to the defense, and that's a huge issue because like I've said before, this is a song and dance show. A trial is a song and dance show. Everyone knows their parts, everyone knows their lines, everyone knows the evidence, and you're just out there performing for the jury in hopes that they pick you. Right? That's kind of what this is supposed to be. And so to be surprised by a witness testifying at an expert level, everything that she's testifying to is to a medical degree of scientific certainty.
Reasonable degree of scientific certainty.
Yeah, reasonable degree, whatever. It's as if it matters at this point with this witness. But so everything she's saying is supposed to be to that level, and now all of a sudden she's talking about something that they had no notice of whatsoever. I feel like that might be a stronger argument for in appellate grounds than any of the testimony of the DNA or things like that, or the way the DNA is presented.
Yeah, I like, well, and if this was a Florida case, and I'll speak from, actually, I had a case reversed on this very topic in appeal, which is very rare. It's a 0.6%, it's on the 6 out of 1,000, and it was based on non-disclosure of testimony and non-disclosure by the state of this type of thing. And so what we're talking about, so usually there's a disclosure, there's a list of witnesses, and then you have a category C, you have a list of expert witnesses. And then the expert witnesses will say, okay, expert on DNA, for example. And then, so that expert, then the defense is put on notice that there is a state witness who's going to testify to DNA. You can interrogate them, you question them, you do a deposition, you ask them about it. Well, if then you add on to that some kind of science of cleaning, which is outside of the scope of what's expected and is disclosed, now you didn't get a chance to hire your own expert. You didn't get a chance to prepare your questions. You didn't get a chance to do anything. All of a sudden, the defense is surprised by this additional evidence that is now being presented to the jury through an expert, again, extra harmful. Now, in Florida, what happens if that's done is somebody says, wait, we've never heard this. This person wasn't disclosed. They have something called a Richardson hearing. And a Richardson hearing, the judge is supposed, anytime there's a non-disclosure of evidence, they're supposed to shut the courtroom down and start and say, was it disclosed or was it not? And is it harmful and is it not? And if it was, what's the remedy here? Now, I don't know if there's a similar process in Wisconsin, and there's different disclosure requirements in different states, but this is a very important issue for appeals, I think, especially, hopefully it was preserved. And what was the level of preservation on this? Do you know?
Well, this is where the judge got confused and forgot that the defense actually objected to it initially, and then remembered once he was reminded that, oh yeah, you did. Still overruled. I'll allow her to testify. Well, and the grounds that the judge allowed her to testify wasn't because the defense had some sort of constructive notice or anything, but that the witness felt comfortable testifying about it. So we'll just go ahead and let her testify.
See, and another thing you might also get, not only do you have the factual non-disclosure question, you also have the question of the judge applying the wrong standard when reviewing the question. And that is a legal question that is reviewed de novo. So you can also construe this. You can construe this error it's an error by the judge. De novo means the judge looks at the appellate court looks at it fresh. There's no deference to the trial court. And an improper standard application by the trial judge is the type of thing that's looked at to de novo. So, for example, if he says, well, I'm going to allow it because X, and he talks, and this judge does talks, that's good, you hear his reasoning, and he's applying the wrong standard, the appellate court can reverse on the basis of wrong standard, which is de novo, which is the no deference to the trial court at all, which is what you want from a defense side. So I like this issue a lot. I would definitely.
Yeah, no, he literally talks through it for like 20, 25 minutes, talking through, well, I know you didn't get noticed, but I feel like she's qualified enough. She said she uses bleach in her laboratory.
That doesn't
I know. Yeah. So it's probably really good grounds for an appeal. And that might actually be the strongest thing appellate wise for this particular witness, Lisa.
But all three of these are good. All three of these are good bases. Where I'm throwing some assessments at you and throwing some, what I'm seeing. But I like all of these points, and A good appeal is a bad thing. I mean, it's really not good that we're here. However, if you're going to have an appeal, it's better to have issues that you can appeal. The problem is this case, it's kind of like when it rains, it pours. There's so many issues that sorting the best ones from the okay ones can get difficult. And so I know that you've retained some good appellate counsel. So pray for a good argument and a good fair judge panel.
All right, guys. So we're coming to the end of the show today. We're at this point. The last witness from today was Christy Radatz Ortiz, which is Rosalio's baby mama. So Rosalio's ex. There's a little bit of her testimony that comes in specifically just to try and convince the jury that Rosalio is dead, with some emotional heartstring testimony that they can argue is worth it because they need to prove that his normal activity is no longer.
Yeah. Okay. Real quick though, she testifies that that Rosalio has kids, that he's always involved in these kids' lives, that he coaches baseball with them, that he has a camp that he's supposed to go with them, and he doesn't do all this stuff. And I will push back on Solomon a little bit here. It's necessary for the state to produce this type of witness and this type of evidence to prove that Rosalio's dead. They have that burden to prove that he's dead. And I think this overcomes the prejudicial versus probative evaluation, just because how else are you going to do it? You have to present some information. And since you don't have the body, this is the next best thing. And it's very common, very typical.
Well, you could have maybe had someone estimate the amount of blood loss in the apartment, but that wasn't done either. So we went for the emotional ploy to try and convince the jury emotionally that he checked out and that he didn't owe tens of thousands of dollars to people before he skipped out. All right, so tomorrow we've got Officer Van Wee, the other evidence technician, and the first day of Celia Patterson. Officer
this
Van
guy,
Wee
I miss this guy. He's such a okay.
He's interesting.
He's coming up tomorrow, guys.
So we'll have some more some exciting stuff tomorrow. Flux is joining us tomorrow night to bring her forensic education to talk about Mr. Van Wee's education and his expertise. David, final thoughts?
Just that it's just I'm rewatching this like for the first time, like all in a row again, and man, I forgot how frustrating like every single thing was in this case. And I just want to thank Steve for coming on and talking about.
No, it's an honor, and I always feel bad because Solomon, I have so many clients that don't have anybody that cares about them, and so whenever I see a family member who's so passionately committed to their family member, you are a great blessing, and Zachary is blessed to have you out there advocating and have the support and the people, the group. And of course, we have us team out here who are absurd, the injustice, but you keeping this in the front burner and keeping it in the public eye and being there for your brother. I can't tell you how humbled that makes me and proud. And so I'll offer what I can in my limited way here in Florida. This is the type of thing that really pains me because I know a lot about it and I know what I can do, but I can't do it. Right. So I'll just offer you my best when I can.
Thank you, Steve. Thank you very much.
Thank you, guys. Come right back here again, 10 o'clock tomorrow, 10 o'clock Eastern, 9 p.m. Central tomorrow for one more, or no, not one more, for day 5. Day 5, we're going to talk about day 5. Thank you all for joining us. There we go. Take care, guys.